home of horror. 4 adults caught neglecting 16 children. Ages are ranging from a little toddler all the way to 18 years old. What investigators found when they got there, and what happens next? Yesterday, the Benton County Sheriff's Office, this is in Ohio, sent out a search warrant. I guess they got from established information and went out to the home to do this search warrant, and where they found 16 children were in such bad shape, living in horrible conditions, so bad that all of them had to be removed, and some of them had to require immediate medical care. They arrested Gary Siders Jr., Elizabeth Siders, and Christina Siders. All 4 are in jail right now. Attorney General Andy Wilson called this scene the most evil he had ever seen in his entire career. I have heard that there were other illegal things going on there, but the authorities don't believe that this is a human trafficking situation. The entire community is stunned, saying that they didn't have any idea that 16 children lived there in the first place. Did they go to school? Did they go to the doctor? Nobody saw them. They weren't allowed to come outside, I'm assuming. This is unbelievable. And though we have not yet seen the pictures from inside, I'm sure we will soon. They did say the charges are going to be second-degree felonies because the children did get harmed inside the home. Now, what harm are they talking about? I'm not exactly sure. We're just now getting information, and I'm sure they're keeping most things under wraps until they get an entire evaluation of the situation so that any other further charges that need to be pressed can be pressed. What do you think about this horrible situation? Make sure you pray for the children and that you bookmark this so you can find your way back.
Who they were bringing me. These are case numbers 26 CR 50 and 53. All right. Let's go over those together, all right? As a preliminary matter, are you okay with doing this by Zoom today? Are you okay with doing this through the computer today? All right. So, actually there are 17 here. I apologize, there are 17 counts on one of these. Each of these counts is a second-degree felony count of endangering children, which is a violation of Ohio Revised Code 2919-22B1 and E2D. Each one of them alleges that on or about June 30th, 2026, that you did abuse a child under the age of 18 years old, and the violation resulted in serious physical harm to that child. Each count contains different initials indicating and birth dates indicating which child to whom it refers. Count 1 is CS, date of birth 5/30/2008. Count 2 is ZS, date of birth 8/17/2009. Count 3 is CS, date of birth 3/13/2011. Count 4 is KS, date of birth 3/28/2012. Count 5 is BS, date of birth 5/8/2013. Count 6 is GS3, date of birth 9/2/2014. Count 7 is LS, date of birth 5/25/2016. Count 8 is VS, date of birth 10/26/2017. Count 9 is JS, date of birth 10/27/2019. Count 10 is ES, date of birth 9/29/2020. Count 11 is NS, date of birth 2/10/22. Count 12, SS, date of birth 2/10/22. Count 13 alleges harm to John Doe, date of birth 1/21/25. That's John Doe A. There's John Doe B, date of birth 1/21/25. Count 15 is simply identified by first name Isaac, no date of birth at this time. Count 16, Isaiah, no date of birth at this time. Count 17, Wade, no date of birth at this time. Those are for you, Mr. Siders Jr., Mr. Siders Sr., those are all the same. Yes, I suspected so, but I wanted to ensure. All right. Each of those felonies of the second degree is punishable by 2 to 8 years as a minimum sentence and a maximum sentence of 12 years in prison. A maximum fine of $15,000 and 18 months to 3 years of post-release control. Do you understand all that? You have the following rights. You have the right to retain counsel even if you intend to plead guilty. You have the right to a reasonable continuance in the proceedings to secure counsel. You have the right to have counsel assigned without cost to you if you are unable to afford counsel. You have the right to bail if the offense is bailable. We will come back to bail momentarily. You are not required to make a statement at any point in these proceedings, but anything you say can and may be used against you. You have the right to a speedy public jury trial. Do you understand? Also, because these cases have come before this court on a complaint rather than an indictment at this time, you would have the right to a preliminary hearing, and you can discuss that with counsel once counsel is appointed for you. Do you understand? All right. The JO has applications for court-appointed counsel there. You can fill those out and they'll submit them back to the court. You have 4 pleas available to you. A plea of guilty is a complete admission of your guilt. A not guilty plea is a complete denial of your guilt. A no contest plea is not an admission of guilt, but is an admission to the facts that underlie the complaint. If you plead no contest, the state would give me a statement of facts, and it would be up to the court to determine whether or not you were guilty of the charged offenses based on those facts. If the facts were not sufficient, I would find you not guilty. A plea of no contest cannot be used against you in any subsequent civil or criminal case, but you would have a criminal record if you were found guilty pursuant to a plea of no contest. A not guilty by reason of insanity plea must be made in writing. Do you understand those pleas? How do you plead? Yes, I will enter a not guilty plea for you at this time then, and you can confer with counsel. Okay? Mr. Siders, would you like me to enter a not guilty plea for you as well? Until you have the chance to speak with an attorney? I will do that. All right, I need to grab this one section. State's position as to bond.
Thank you, Your Honor. May it please the court, at this time, the state will be requesting a $300,000 cash assurance bond for each defendant under the court standard terms and conditions, including special conditions that they have no contact with each other as co-defendants and they have no contact with the victims. And if they are able somehow to post bond, that GPS monitoring at their expense.
Gentlemen, do you have anything to say as to bond?
No, I didn't want to hear it.
They ask for a $300,000 cash or surety bond, and that if you are in no contact with your co-defendants or with the alleged victims, and that if you are released on bond, that you be required to wear a GPS monitor. Do you have anything to say as to any of that? All right, I will grant the state's request then. It will be a $300,000 cash or surety bond. In the event Well, first of all, no contact with your co-defendants. Don't be speaking with each other there at the jail. If you are released, no contact with the alleged victims. Don't try to contact them from jail either. And you will be required to wear a GPS monitor at the state's expense. You would also be required to be a law-abiding citizen, keep the court informed of any address or telephone number changes, appear at all hearings, and have DNA and fingerprinting done if you've not done so already. Do you understand? All right. Anything else from the state?
No, thank you.
All right. Gentlemen, we'll get you attorneys appointed as soon as possible. Thank you. I will be right with you. Yes.
Do you not have a copy of the amended complaint?
I thought that was what they put in here.
Yeah, that was the original.
What changed?
It's 16 counts, and we identified the kids with their actual dates of birth and removed, so their names weren't listed on there. We used their initials then.
Okay, I'll change it to initials.
You want me to go get it?
You can.
Okay.
I apologize. The prosecutor went to get a piece of paper or some paperwork from the clerk's office. We will be ready to proceed in just one moment. Did they put them behind the others?
I think they probably did.
I think that's why I flipped through and found something different.
Yeah, I'm sorry.
It's
Yeah,
okay.
they're there. I apologize.
It's not a big deal. I knew that they were filed. I just wasn't sure which one was the original and which one was the amended. I thought maybe they just took the other one out. All right. We are on the record in the Benton County Court of Common Pleas. These are case numbers 26 CR 51 and 26 CR 52. Case 5-1 is the State of Ohio versus Christina Siders, and Case 5-2 is the State of Ohio versus Elizabeth Siders. Is that the two of you? And ma'am, you on the left, you're Christina, and you're Elizabeth. Is that correct? All right. The purpose of today's hearing is to advise you of your rights and the charges against you and to set a bond, all right? Have you received copies of the complaints against you? I believe that they filed an amended complaint this morning, which may differ slightly from what you received. They have gathered some additional information regarding dates of birth and initials for the children. So that would be the only difference. And also have revised the complaint from 17 counts to 16. Okay? Did you have the opportunity to read that complaint? Okay, I'm going to go over it with you because these are serious allegations and I think it's important that you understand what we are talking about, all right? These complaints are identical. They each contain 16 counts of endangering children, which is a violation of Revised Code 2919-22B1 and 2919-22E2D. All of those counts are felonies of the second degree. All of those accounts allege that you did in Hamden on or about June 30th, 2026, unlawfully abuse a child under the age of 18, and that violation resulted in serious physical harm to that child, okay? Each count is different in that it identifies a different child by initial and birthday. And so we will go through those quickly and then talk about the rest of what we need to address today, all right? Count 1 refers to CS, date of birth 5/30/2008. Count 2 refers to ZS, date of birth 8/17/2009. Count 3 refers to CS, date of birth 3/13/2011. Count 4 refers to KS, date of birth 3/28/2012. Count 5 refers to BS, date of birth 5/8/2013. Count 6 refers to GS3, date of birth 9/2/2014. Count 7 refers to LS, date of birth 5/25/2016. Count 8, BS, date of birth 10/26/17. Count 9, JS, date of birth 10/27/2019. Count 10, ES, date of birth 9/29/2020. Count 11, NS, date of birth 2/10/22. Count 12, SS, date of birth 2/10/22. Count 13, IS, date of birth 1/21/25. Count 14, IS, date of birth 1/21/25. I assume that those are two separate children that are perhaps twins. Count 15, BS, date of birth 1/4/24. Count 16, WS 1/4/24. Felonies of the second degree are punishable by a minimum sentence of 2 to 8 years in prison, a maximum sentence of 12 years, and a $15,000 maximum possible fine. They also carry the possibility of 18 months to 3 years of post-release control. Do you understand the charges against you? I need you to answer out loud because we're keeping a record. All right. Doesn't mean you agree with them. I just need to know that you understand what they are. You have the following rights. You have the right to retain counsel even if you intend to plead guilty. You have the right to a reasonable continuance in these proceedings to secure counsel. You have the right to have counsel assigned without cost to you if you are unable to afford counsel. You have the right to bail if the offense is bailable, and we will discuss bail momentarily. You are not required to make a statement at any point in these proceedings, but anything you say can and may be used against you. You have the right to a speedy public jury trial. Do you understand those rights? All right. The jail has applications for court-appointed counsel. If you wish to fill them out, they will send them back to the court. You have 4 pleas available to you. A guilty plea is a complete admission of your guilt. A not guilty plea is a complete denial of your guilt. A no contest plea is not an admission of guilt, but it is an admission to the facts that underlie the indictment. If you plead no contest, the state would give me a statement of facts, and it would be up to the court to determine whether or not you were guilty based on those facts. If the facts were not sufficient, I would find you not guilty. A plea of no contest cannot be used against you in any subsequent civil or criminal proceeding, but you would have a criminal record if you were convicted under a no contest plea. A plea of not guilty by reason of insanity must be made in writing. Do you understand these pleas? And how do you plead? Stop. First of all, I want to remind you of your right to remain silent. This is not the time for you to argue your case. These are serious allegations, and if you are unsure on what to do, I will enter a not guilty plea for you until you can consult with counsel. Okay? I also need to advise you that because these cases came before this court on a complaint, as opposed to through an indictment by the grand jury, you have the right to a preliminary hearing. And that's a matter you can discuss with counsel once they're appointed as well. All right? All right. So I will enter not guilty pleas for both of you at this time until you have the opportunity to discuss this case with counsel. State's position as to bond.
Thank you, Your Honor. May it please the court, it is the state's recommendation that a $300,000 cash or surety bond be imposed on each defendant based on the seriousness of the offenses that under the court standard terms and conditions, including special conditions that they have no contact with co-defendants, with each other, and with the victims, and that if they were able to postpone, that they would be subject to GPS monitoring.
Could you hear the prosecutor? The state is asking for a $300,000 cash or surety bond, and that if you are able to post bond, that you have no contact. Well, sorry, let me back up. Even if you're not able to post bond, they're asking that you have no contact with your co-defendants. That means each other. I presume the jail will keep you from having contact with the other 2 co-defendants if you remain in jail. No contact with the alleged victims of the offense, and if you are released, that you be fitted with a GPS monitor at state's expense. We also have general conditions of bond if you are released, which include that you be a law-abiding citizen, that you keep the court informed of any address or telephone number changes, that you appear at all court hearings, and that you get DNA and fingerprinting done if you have not already done so. Do you have anything to say as to bond? You can discuss with your attorney. They could file a motion to modify bond, and the court will consider that at that time. Okay? All right. Is there anything else from anyone?
No.
All right. We'll get someone appointed as soon as possible.
Thank you.
Thank you. You too.